may resume. I think that mic's not on.
I want to close this loop on these documents. You heard my colleague, Mr. Hardin, say that these documents had never been produced to us. We haven't seen these documents. Your Honor, the documents are bait stamped with their bait stamp. They sent the documents to us. And then when we sent our exhibit list back to them, it was sent to Mr. Hardin, and I'm told he failed to forward it to the rest of his team. So, you know, I've withstood a few criticisms from Mr. Hardin, which is fine. You know, that's his job. But to suggest that he's never seen the document, that we didn't give him the document, and to object to a document that he gave to us, pretty ridiculous. So we would offer into evidence the two documents that we were discussing before the break, just to confirm AG 368 and AG 361.
If I may, I told the court that I would look into it, and I think I have it. I think I have the sequence right. This was a document that the AG's office produced to us in August, and in compliance with your order, we tried to turn them around many times within 24 hours, certainly as soon as we could. We produced this document, along with a lot of other documents, back in August, so almost 2 months ago. When we produced it, it was produced in mass, just like this. It was never listed on their exhibit list, and it was never listed as a proposed list. I'm sure Mr. Buzbee maybe inadvertently spoke now, I'm sure not deliberately, but he didn't add that when the first time we knew they were going to list it as an exhibit was last night. And the first time we saw it as an exhibit in type was today at noon. That's what led to all this hullabaloo. It is a forensic report for the court to understand that was done back in 21, where the agency, after these people left, went to all their computers and did a forensic report looking for evidence and things. And in this one, this was a forensic report done on the computer of Lacey Mays. And that's the sum total. So he is right in that we produced it to him. He's somewhat misleading in discussing when we got it as an exhibit, and we're on notice it was going to be offered as an exhibit. But now that we've looked at it and all, I'll be glad to waive my objection. We'll be glad to have it be admitted and let the jury look at it and understand what it is.
Thank you. Mr. Hardin. Yes, so he doesn't object. You can enter it into the exhibits.
Yes, Your Honor, thank you. I want to make sure I understand. Put it back on the screen, please. Actually, let's just make sure we focus on what this witness sent. Eric, put 368, AG 368, which is now in evidence, that we received. You can see, go to the email sent by this witness. Now, sir, I want to make sure we all understand this. You went to the FBI on September 30th, the day before you sent this email, right?
Yeah, he enlarged it. Can you put the date so I can, I'm sorry. Can we, the Madam Court Reporter keeps telling me that when I look at the document, I don't speak into the mic, and so I'll try to be deliberate. Yes, it is dated. It looks like if this date is correct, is October 1st, 2020. Listen
to my question.
Yes, sir.
You sent this email the day after you went to the FBI, isn't that right?
You know, now that I see that date, that time, there's no way Jeff Mateer is up at 1:39 a.m.
So you dispute the email that was sent from your email address?
No, sir. What I'm saying is it has a date stamp on it with a time stamp. That there's no way I sent it on that at that time. I'm not disputing that I sent an email.
On that date?
I think that date or the day before, the timing could be somehow screwed up on the computer. I don't know.
Let's make sure we have a clean record and everybody knows what was going on. You went to the FBI. You reported what you claimed to be crimes. And then And then you told one of your subordinates to allocate $50,000 for a lawyer. Isn't that right?
To set aside unobligated reserves in the event we did enter into an outside counsel contract, and the we being the agency.
And you did that. This lawyer, Mr. Sutton, who represents you now, was supposed to be helping Ken Paxton some way?
Potentially, we wanted to meet with Mr. Paxton on October 1st.
With a lawyer?
No, it was going to be just the deputies first, but perhaps that could have led to that had he met with us.
Mm-hmm. So you wanted a lawyer to meet with you with the AG? I'm trying to figure out, why are you using state monies for a lawyer for your personal use?
I wasn't, and I didn't, and I wouldn't.
I guess from your point of view, it's okay to step outside of the procedure when you want to hire an outside lawyer, but it's not okay for the elected attorney general to do so. Is that right?
That's absolutely false.
Now, are letters sent by the Attorney General of the state of Texas official documents?
Yes.
They are official documents, are they not?
I believe so.
Let's all be clear. According to the former first assistant, your position is that letters sent from the AG's office are in fact official documents, correct?
They're documents from the office, and they would be, depending on the subject matter, I believe so.
Are you familiar with Texas Penal Code 37.01?
You've got it on the screen.
Let's look at it. Let's bring it up where we can see it, Eric. Can we have it bigger, Eric? There we go. Now scroll it where we can read it. Tell me if I get this right. A person violates 37.10A when he knowingly makes a false record in or false alteration of a government record. Did I read that right?
You read the document, yes?
Before I showed it to you and read it to you, were you familiar with that particular provision of the Texas Penal Code?
Sitting here, perhaps. I don't know.
Exhibit 127, Exhibit 19, please, Eric. All right. What we have here is a letter sent on the same day you guys went to the FBI by your subordinate, Mark Penley, correct?
That appears to be a letter September 30th to Mr. Kamek from Mark Penley, correct?
Who altered this government record?
I don't follow you.
What?
I don't follow you. I don't think this document was altered.
Do you see the letterhead that this letter was sent from?
I see the seal of the Attorney General on it, yes.
Do you see the Attorney General's name?
I do not.
Who removed it?
I don't know.
Would you ever countenance that?
I'd have to know the circumstances.
Well, these are the circumstances. It's September 2020, and your subordinate is sending a letter, an official letter from the AG's office, and he removes your boss's name. Would you ever countenance that?
Again, we'd have to ask Mr. Penley.
I'm asking, would you ever countenance that?
I don't know in this situation. I don't think this letter was altered because it does have the seal.
Would you authorize that? Would you authorize removing the duly elected Attorney General's name from official correspondence? Would you authorize that?
Again, I don't know if that's required or not.
Would you do it yourself?
I am anticipating that you're going to show me a document.
I am indeed. My question is, would you have done it yourself?
I don't know if Mr. Penley focused on that. I don't know if I focused on it. We obviously didn't. We don't print out the letters. They're brought to us and we sign them.
Yeah. Somebody, this is not a situation. I mean, this is official letterhead of the office. Somebody had to do whatever it takes to remove the duly elected Attorney General's name from the official letterhead. Isn't that right?
I don't know what the process would involve.
Exhibit 30 within 127, Eric. Last page. Nope. There you go. Do you see that on the same day you were allocating $50,000 for Johnny Sutton, you were also sending a letter to Brandon Kamick?
Again, we discussed what we did with regard to Mr. Sutton. I do see that I sent a letter or signed a letter on October 1st, 2020, sent via.
You signed an official correspondence from the Attorney General's office of the state of Texas that had his name removed. Isn't that right?
That's what this shows. I did not focus on that at the time.
Who gave you the authority to do that? Who gave you the authority? Someone that you've already admitted have never run for office, have never gotten a vote, the authority to alter the official letterhead of the Attorney General's office.
I mean, as I mentioned to you, Mr. Buzbee, I didn't do that. I signed a letter.
Well, who did it in the office? That somebody had to be working for you because you told us you control the day-to-day activities of the office, remember?
I don't know who did it.
And it was just an oversight on your part that you were signing a letter that had your boss's name removed? Is that your testimony to these jurors?
My testimony is that is not something I would have been focused on October 1st.
You were involved in staging a coup, weren't you?
Absolutely not.
That's what you were up to.
Absolutely.
That's the reason you went to the governor's office. That's the reason you were talking to TLR. That's the reason that you had or engaged in conduct removing your boss's name. You were staging a coup, weren't you?
Absolutely not.
The Mitty Foundation, we saw that you signed off on that, right?
We reviewed documents that I approved the investigation and I approved the intervention, correct, sir?
You remember you talked about you came back from vacation and that you realized, you found out that a legal opinion had been issued. Remember saying all that?
About the foreclosure?
Do you remember saying?
I'm asking for clarification,
yes, sir.
Is it about the foreclosure letter?
Yes, sir.
Yes, I remember.
You called it a legal opinion, didn't you?
If that's what the record shows, it was a legal opinion. It was done by lawyers, the Office of Attorney General, under, I believe, the disaster authority.
In fact, Eric, put on the screen, please, Article 2 of the impeachment articles. All right, I just want to, for the sake of clarity, one of the charges in this case is that General Paxton misused his official power to issue written legal opinions under subchapter C, chapter 402 Government Code. Do you see that?
I see what you've read, yes.
Now, let's look at the legal opinion that has been referred to. Go to Exhibit 12741, Eric. Before we turn the page, why don't we look at the official letterhead of the Attorney General's office? You see it there?
I see, yes.
Of course, that's not the letterhead that you used on October 1st, is it?
No, the two documents are...
You altered it, didn't you? Or you had it altered?
No, sir.
Mm-hmm. But focusing on Article 2 of the impeachment articles, go to the second page, Eric. Actually, third page. It's the last page, Eric. There we go. Would you do me the favor of reading the very last sentence in that paragraph?
Okay.
Please read it loud so our jurors can hear you.
Again. Please note, this letter is not a formal Attorney General opinion under Section 402.042 of the Texas Government Code.
It's pretty clear, is it not, that this letter does not fall under legal opinions as defined in 402.042, correct?
Well, Mr. Bangert says what it says. It's not a formal Attorney General opinion.
Right, but the article of impeachment says it is. And you know, as a lawyer, it fails. Right there, dismissed, right?
I don't know that.
Well, I mean, you allege, hey, you violated, you did something wrong, you issued an opinion under 402.042, and it takes us literally 20 seconds to show that's not true. That fails, right?
I don't know what you're asking me.
It's almost like somebody read the first 2 pages but failed to read the last page when they drafted these articles, isn't it?
You're asking me to speculate concerning...
How many foreclosures did this letter stop?
I don't know.
None. Did you know that?
I don't know.
Now, grand jury subpoenas are supposed to be secret. Is that right? How does that work? Do you know?
I don't know.
Okay. Are you supposed to, would it be appropriate for somebody in your office to send issued grand jury subpoenas, copies of them, to some sort of outside lawyer who's not involved in the case?
I think it depends on the circumstances.
Was it appropriate to send the grand jury subpoenas that Mr. Kamek had issued to Johnny Sutton?
I believe in this circumstance it was.
Was Johnny Sutton the office's lawyer at that point when that was done?
Johnny Sutton was never the office's lawyer.
Okay. Was he your lawyer when that was done?
What date was it done on, sir?
Exhibit 35 of 127, Eric. Wait a minute. Hold up, Eric. Let me make sure I got it right. Let me just, before I grab the document, when would it ever be appropriate for either you or any of your subordinates to send grand jury subpoenas or copies of them to some outside lawyer who had not been hired yet?
Object to the form. That's a misstatement. He doesn't know. He doesn't know when he'd been hired.
Well, let's figure that out. If you're asking me, I'll ask him. We were told previously that, you can't know when he was hired, so let's figure it out now. When did you hire Johnny Sutton?
I believe we retained him during that last week that I was First Assistant Attorney General.
Whoa.
Personally.
Wait a minute. You're telling us that you hired and retained Johnny Sutton while you were still at the office?
Correct.
And at the same time, you're allocating $50,000 to retain him?
And we make the decision not to do that.
Wait a minute. Okay, help me on this. If this is news, you're saying under oath that while you were an employee of the Attorney General's office, before you resigned, that you had already hired Johnny Sutton. Is that right?
I believe that's so.
What day?
Whenever that first contact was.
He says in his subpoena, trying to quash the subpoena, it was before you went to the FBI.
I think that's correct.
Okay, so now we're all clear. You personally had hired Johnny Sutton, an outside lawyer, in your individual capacity before you went to the FBI. Is that right?
Correct.
And at the same time, in fact, the next day on October 1, you were telling Lacey Mays and the controller to set aside $50,000 for Johnny Sutton?
For the office to retain Johnny Sutton.
You were going to have Johnny Sutton represent you individually and also the office, and you were going to have the office pay for it?
No, that's not correct. I mean, it is not uncommon.
You realize now what you just testified to?
Could you let him finish, please? Just finish his answer.
Do you realize what you just testified to?
No, sir.
You just told this entire jury that you had hired an outside lawyer in your individual capacity before you went to the FBI on September 30th, 2020. And the very next day, you were instructing your subordinates to set aside $50,000 for Johnny Sutton.
And the agency never hired Mr. Sutton. The agency never paid any money to Mr. Sutton. The funds were never used in that way. The decision that we made was the agency not to hire him. That never happened.
The decision we made?
Me and the other folks.
Can you help me understand? I guess you've told me now Johnny Sutton was your individual lawyer while you were still at the office. Was he an individual lawyer in the individual capacities of other of your subordinates?
I believe so.
And so your testimony would be that if your subordinates were sending secret subpoenas that had been issued by the Travis County District Attorney's Office, that they were able to do that because Johnny Sutton was their personal lawyer?
I believe it was done pursuant to a request from the FBI.
To send to Johnny Sutton?
To send to Sutton and then to the FBI. That's what I understand.
So the FBI, these subpoenas that everybody's complaining about, at least those folks, were sent to the FBI 3 years ago. Nothing's happened so far, right?
I don't know if nothing has happened.
Are you here testifying in any way that Nate Paul had anything to do financially with the renovations of Angela and Ken Paxton's home?
I only know what I've been told.
Told by who? Again, you mean Rylander and Wicker?
Remember, I testified before lunch about that, sir.
Okay. Did you ever make any effort to confirm that what you had been told by one of those two was correct?
I did not.
Okay. You just believed it.
I believe Mr. Wicker and Mr. Rylander are truthful people.
Did they ever look at the invoices?
You'd have to ask them, sir.
I will. Okay. I'm asking you. Did you ever look at
I never asked them if they looked at the invoices.
Okay. Do you have any evidence whatsoever, other than what somebody, and you're not sure which one, told you that Nate Paul had anything financially to do with the renovation of the Paxton's home?
Did you say that again? I'm sorry.
Do you have any evidence, to support any allegation that Nate Paul paid for any of the renovations of the Paxton's home?
Other than what we discussed.
Pass the witness.